We're on recording. Yeah. Cool. Okay, you're welcome everyone. Just bear with me a sec whilst I do the usual back office things. Um, I've got no camera this week, so it's just a 5-year-old or 6-year-old picture of me, unfortunately. Hope you guys are dealing with the heat all right. Shannon's not with us tonight. Let me just click these buttons here, turn that on, and um, no, not that one. Hold on, just trying to do the old anonymization thing. Here we go. Yeah, cool. So yeah, welcome to tonight's live stream. Just get rid of that, put that there. Cool. Yeah, cool. Right, good to go. Yeah, obviously not legal advice. We're going to do our best here to yeah, to be helpful as we can be. Um, and I guess just as always, if you could make sure you don't disclose personal data in the live chat. So I think all the questions that came through the week were all anonymized, which is awesome. So appreciate that. Thanks, guys. We're going to do those ones first, and then we'll get into the live stream as we go down. But yeah, if you don't anonymize the question, as in if you ask it in the first person about yourself, I'll remove it and ask you to rephrase it. So I hope that makes sense. Um, yeah, cool. So let me get the screen shared so we can see the questions. Any gossip from you guys, Will and Karis? You doing all right? Um, for those who didn't manage to come to the webinar we did last week, the recording's up and running now on the channel. So it's about kind of going through the entire homeless application flowchart, which is a bit of a monster. But yeah, so just have a look at the recording if you missed it. Yeah, I'd say it's a pretty good one, really. Yeah, other than that, let's get onto it. So this is the first question. Now, this question here actually builds on a situation that was being asked about last week. So um, for those who kind of were around last week, it might seem familiar, but there is an additional question aspect to it. So if we just start from the top, what if someone has mobility problems, mental health problems, multiple supporting letters from the GP psychiatrist, and is living in unsuitable accommodation not provided by the council, private rented accommodation for a few months now? They cannot safely use the bathroom, fit into the shower in a normal way. The studio flat is on the first floor. Council completely ignored under Section 202. On the 20th of May, solicitor confirmed that no decision reply from the council was received, and solicitor replied to County Court Section 204. No response from the council about interim accommodation. A person has a meeting with the solicitor in a few days at the office and is going to ask a solicitor to apply to the county court for interim accommodation. Unfortunately, most of the time there is a lack of communication with the solicitor. If a solicitor refuses to apply for interim accommodation with the county court, are the only two options to firstly try to speak with a different solicitor or wait for the hearing. Can you please explain? So, right, the first thing that strikes me about this question, because there's some additional question in here that probably wasn't included in the last set of questions about this, in that it seems to me to be a decision about whether this person is legally homeless whilst living in private rented accommodation, which potentially wasn't something which we picked up on last time. And so what that means is it is possible to argue that you're legally homeless if you're living in accommodation of some kind, because although you might have accommodation, it may not be reasonable to continue to occupy. And suitability around disabilities are very relevant. There's a fairly, well, not that recent case from 2018 called Lomax v Gosport, and it's a very convoluted argument, but in effect, in that case, because Miss Lomax had a disability in the form of her uh, depression, which was leading her to get very isolated, kind of leading to kind of get worse because she was so isolated in her home. The way the council had to therefore consider that ultimately meant that she was found to be homeless and therefore she could apply to Gosport. She was from Dorset. But it's, as I say, it's a very complicated argument. But in effect, one of the potential challenges in this situation would be to ensure that the council has actually properly considered the person's disability. And in the Gosport case, what actually happened was the council treated this person, Miss Lomax, as essentially, kind of no different from anyone else, when actually she had a very marked disability. And because they hadn't correctly differentiated between her and other people on, on the housing waiting list and stuff, that was the thing they lost on. So that might be something which would need looking at. But in terms of the actual answer to the question, um, the straightforward answer is if you want to change solicitor, you need to complain about your existing solicitor and then find a different solicitor with capacity, which is hard, or you wait for a hearing. But I guess it's probably important to say, and Will and Karis, I'm sure, can add more to this. But just, solicitors, the nature of kind of lawyer day-to-day work is that things can kick off with a case and kind of require a lot of effort, court hearings and so on. You might have to travel to court and stuff like that. And therefore, just because your solicitor's not responding kind of immediately, that doesn't necessarily, it's not necessarily a problem. I mean, in this case, potentially would be, but I think in one sense, this is probably a more difficult question or a difficult argument to make. And so I guess it makes it more likely that the solicitor might not see merit in challenging it. I don't know. I'm speculating heavily there. But yeah, Will or Karis, I don't know if you want to kind of, add to that, kind of explain a bit more about that, kind of, just give a bit more background to it. No, you're good. Will, you're on mute.
Okay, sorry, I was seeing if Karis wants to say anything, but there's two different issues here, aren't there? There's one is the issue about the substantive legal issues in the appeal, oblique interim appeal, and the other is communication problems with a solicitor. And I think we talked about the communication problems with a solicitor last week. And I suggest that if you can't speak to the solicitor, then you maybe find out who's responsible for supervising their work and contact them. It's going to be difficult to get another solicitor. Most solicitors would be reluctant to take on a case at that stage. But the other thing about the substantive issue, as I say, if the council's position is, if the decision was what you think it was, Mike, that they're not homeless, that the council is not going to give them accommodation because they don't think they're homeless. And so the purpose of the appeal is to challenge that. And it would therefore, if you ask for interim accommodation pending the outcome of the appeal, you're sort of asking the court to determine the whole thing at an interim stage, because in order for them to give you interim accommodation, they'd have to accept that it was likely that you were homeless. And they might be reluctant to do that, given that it's all interim injunctions are about balance of convenience. And if you've already got accommodation and the council have thought about it and said, no, we don't think you're homeless, it's unlikely a court's going to step in and say, we think you are homeless at the interim stage. So I think it'd be very difficult to do. But I mean, I appreciate you feel you may be entitled to an explanation from the solicitor about that. Does that make sense? I'm sorry if I'm waffling a bit.
No, it makes sense. I'd say that it's probably, I mean, it's very jargon heavy by nature of it.
Mm.
So I guess it'd be important for a solicitor to kind of lay that stuff out in layman's terms in the situation. I think something that if this person hasn't already done here is to pursue potential support from adult social care, because there may be some interim adaptations they can make, some kind of low key ones, things like, I mean, again, we don't know what the exact issues are here, but things like, a shower stool and stuff like that, so you can kind of access the shower more easily. It's unlikely they're going to be able to make any physical adaptations to the property, but it may be there are some things which might make it slightly more comfortable whilst they wait for this kind of process to go through. So yeah, I've just seen the live chat. You right, Sanjay? You right, Cheeseface? We got Tiff here tonight. Yeah, you right, Martin? So yeah, that's kind of. Hopefully that's kind of answered it for the time being. Karis, you got anything to add to that at all? We good?
I mean, Will and May have already addressed this, but the term refuses to apply. They should have explained to you if they're not applying for it, why. And you can ask that question, why not? So always ask the why not, and they'll explain to you why not. It's not been applied for.
Yeah. Okay, cool. So yeah, I'd say hopefully there's some information which should be helpful there. Although it does sound like it's gonna be a difficult one to kind of kind of have to wait on. So yeah, hopefully that person can kind of just find a way to make it more bearable in the meantime. Question 2 is a person submitted a first stage complaint to the council, everything written properly in order, including councillors. As an appeal to the county court is ongoing, could it have an impact on the complaint? For example, could the council say that as an appeal to the county court is ongoing, that they will not take any action, for example, a formal investigation of the complaint, or the possibility of things like compensation and an apology? So this, yeah, I mean, councils can do this. I'm not actually quite sure it's a rather interesting and kind of complicated differentiation between things you can complain about and things you can't complain about, because if my speculation is correct about what might be happening here, if it transpires that that this person is in fact homeless, that their accommodation isn't reasonable to continue to occupy, and that's upheld by the court, then the LGSO would, it might have to wait for that to kind of run its course, but the LGSO would look at the council's records and say, let's see evidence that you properly considered this person's medical issues, which sounds like they haven't. And so actually at that point, the LGSO might, once you've gone through the complaints process in the council, they might well be in a position to actually recommend compensation down the line. But I mean, it's kind of slightly two different issues. The LGSO is looking at, or the complaint process is looking at, did the council look at the right things, consider the right things, ignore the irrelevant things? Is there evidence within their records that they actually assessed this person's needs and kind of made some kind of rational decision about whether the fact they're not homeless? I mean, I guess the council's position might be that there's no reason to think they even might be homeless, but I think that would be a bold kind of position to try and take. Whereas, I mean, I guess in some level the county court isn't doing what you actually think it might be doing. It's not asking, is the decision right? It's asking, it's kind of asking, is there an error in law here? Will and Karis again correct me about that, because I'm not familiar with the county court process. But again, when you go to court, you're not actually necessarily getting the court to decide on the actual question at hand. You're basically asking the court to work out, does the council need to make a decision again because they erred somewhere down the line? So, but I think that doesn't mean. I mean, I've had lots of situations where there is an ongoing appeal or review or whatever, and yet the council has been fully able to deal with the complaint as well, even if they might, they're likely to not uphold it anyway. That's the kind of way complaints work. Is they probably, well, they almost certainly won't uphold the first stage complaint. They may well not uphold the second stage. It's not often until you get to the LGSO stage that they actually start taking it seriously, and that's just kind of, again, it's just council's tactics of batting people away and just knowing that a lot of people will give up along the way. So it's an interesting question. I'm not actually quite sure where you can find out exactly what the LGSCO's remit is. I don't think it's easily accessible on their website, and kind of, there are certainly a lot of cases that the LGSCO publish where they'll say we can't investigate this because this is a matter that could go to the county court. But when it comes to suitability of accommodation, as I say, there are many decisions that the LGSCO make which basically look at not whether the accommodation was unsuitable, but did the council actually ask the right questions about suitability in the first place? That seems to be the thing that gets people compensation. So yeah, Will or Karis, do you want to add anything to those ones at all?
My gut feeling is that the once there's legal proceedings ongoing, everybody who would deal with a complaint tends to sort of say, "Oh, we can't investigate this because there's ongoing legal action." So I suspect they wouldn't. The fact that there's an ongoing county court appeal would would stop them dealing with the complaint until the outcome's known.
Yeah. Okay. I mean, yeah. I think whatever. I mean, proceed with it and see what the council say. So as I say, there's nothing to lose by trying and just seeing what happens. And as I say, the council might say we can't investigate this whilst it's going to court, but that doesn't mean to say it can't be done down the line. And in one sense, if you've raised it at that point, then the LGSO are much more likely to consider it if it ends up being out of time, because there's this 12-month time limit on taking it to the LGSO. But there are many situations where the LGSO will still investigate if there's a good reason why there's a delay, and I guess this would be one of them. So question 3, say someone had fled domestic abuse, but there's not much evidence. They have had to flee the house. The council have put them in a hotel in temporary accommodation. Will they be owed the main housing duty, or can anything go wrong? So sadly, yes, things can go wrong, for sure. But the fact that councils placed them in a hotel in temporary accommodation, that is a good sign. It's by no means going to guarantee that the main duty is going to be accepted. But what the council haven't done is basically just batted it away, kind of right at the beginning. So clearly they've accepted there's reason to believe this person might be homeless and in priority need because they were subject to domestic abuse. I mean, in terms of the threshold is obviously low. So the threshold to get into temporary accommodation or interim accommodation, I guess technically, is low. So if the council's doing their job correctly, there will be situations where they accept the initial duties triggered, but then when they make inquiries, they basically come across information which means they can be satisfied the actual risk of domestic abuse is not going to continue for some reason. That could be for a number of different reasons. So that's in one sense, that's what's probably going to be happening right now is the council housing officer will be or should be making inquiries of anyone who can give information. And there will be cases where no one is around to actually give information. So that's entirely possible. But yeah, but they are at liberty to conclude their inquiries and actually be satisfied that there is not an ongoing risk of domestic abuse, which in effect is what everything hinges on. So there's plenty of opportunity for housing officers to get this wrong because actually the law around domestic abuse is actually quite complicated, and many housing officers have never had any training on it whatsoever. Plus, they're under this huge pressure from their boss to basically get rid of whoever they can sometimes, or a lot of the time. So, but I'd say it's a good sign. I think all you can do is just basically be very compliant with any inquiries that are made, just be very clear and kind of give, kind of open and kind of honest answers about anything you get asked, and just kind of wait for the 56-day relief period to kind of to pass by. So yeah, I think where there's not, I mean, yeah, a lot of councils will basically immediately jump to police evidence or kind of IDVAs and stuff like that, Mareks. But there may be other evidence that you may be able to get. Might be another professional somewhere. It might be something, maybe like text messages that have been exchanged that would kind of show that there's threats and coercion and control and that kind of thing. So, but yeah, I mean, going back to the kind of real kind of baseline, the LGSO has basically said that council's default position should be to believe people who disclose they've been abused. So in one sense, in the absence of any evidence to the contrary, the council should by all accounts accept the main duty if that person's eligible for housing assistance, as in if they've got recourse to public funds. This actually ties in with the question which I haven't brought across from the YouTube channel this week, but basically it was an interesting question. I answered it kind of in writing, so I didn't kind of bring it here, but effectively it was said, is this information or can this information be abused, and can people basically use it to get housing unlawfully? And the answer is yes, they can. All this stuff can be abused. It's particularly easy to potentially misuse domestic abuse law within housing. But within English law, we've got this principle that it's better to have 10 guilty people go free than to have one innocent person suffer. And, in reality, the vast majority of people I've ever worked with are honest. So that, yes, there will be one or two people who try it on and kind of use the system. But the reality is that, yeah, there's no defense against that really in the real world, other than prosecuting people who turn out to have lied. But that's ultimately council's job is, if councils are doing their job properly, there will be people who they house who actually may be trying it on, but the majority of people will be honest. And if the council's taking the right threshold, then they'll be ensuring that people don't get left in harm's way because they've basically, applied the wrong threshold to them. So, yeah, that's my answer. Will and Karish, you got anything to add to that at all? Will, you're on mute.
Sorry, I keep doing that. No, I think you said everything on that one.
Cool. Okay.
Sorry, can I just add, when the councils obviously sometimes get this wrong, and it's explicitly stated in the homeless code of guidance that they cannot contact the alleged perpetrator. So please bear that in mind, that they can't go and talk. So often they'll say, well, can't you rectify it? Or they'll go and talk to the person. And I don't really know what they're trying to say. Like, no one's going to just admit and say, yes, I was abusive. So always be aware that it's written explicitly stated they aren't allowed to go and talk to the perpetrator to get information from. That's all.
So, speaking of which, Karis, so I'm continuing to kind of put together these LGSO decisions for the database, and there was one which I picked up on yesterday. I'm just going to bring it up for you, so you can see the decision. And I've lost the ability to type, so hold on a minute. Here we go. So I think it was Tower Hamlets. Yeah, so basically, let me just share the screen. Hold on. Stop sharing that one. start sharing this one here. So for those watching, if you just type this code here is what you want. So you can just see it in the recording. If you type this code into the LGO decision database, which is just lgo.org.uk/decisions, this is the actual decision here. And so the summary of the complaint is the council was at fault for contacting the alleged perpetrator of domestic abuse against Miss X as part of its inquiries into homelessness. The council has agreed to apologise and make payment to recognise distress caused and act to improve the services. So I think they had to do training. The staff had to do training. So that's a very, it's a common situation where councils, as Kara said, will kind of contact the perpetrator and say, are you abusing this person? And obviously that's going to, if they are, that's going to probably provoke much, further abuse. So yeah, have a little look at that decision to kind of get me more information. And speaking of which, in terms of other resources for people to kind of look more into this, the LGSO have done 2 reports about domestic abuse since the DA Act came in 2021. So the most recent one was in 2024, like September time. If you just go on their website and just search for domestic abuse, you'll find them. And they again give a whole, particularly the 2024 one gives loads of case studies of councils getting it wrong. And what's clear is that councils get it wrong a lot in many different ways. So if you're kind of approaching a council on the basis of domestic abuse, I'd say have a look through those decisions to kind of get an idea of what the law is and how councils tend to break the law, basically. If I was organised, I'd put the links into the chat, but I'm not that organised this week. I've only got one screen. And yeah. So, but yeah, go on the LGSO website, look at their focus report section, and there are, just search for domestic abuse, you'll find them. Sorry, Karis. Oh, sorry, yeah. I'm on set. Right, let me get.
Going to say, do you want me to be the link person?
Yeah, if you put it in the Zoom chat, I'll transfer it over because I don't think you can put links into the live stream directly. Right, what we're doing, losing the ability to do anything right now. Here we go. So yeah, question 4. If someone is in private rented accommodation, can they still apply to go on the housing register? I know it take years for a person to get a property, but what if they wanted to get the ball rolling? So let's say hypothetically, let's look at Bournemouth, Christchurch and Pool's policy, because yeah, why not? And so again, you can find the reason we're going to look at a particular policy here is that councils across the country have different policies and different kind of banding and different criteria to be able to get onto the housing register. So you have to, the only way you can find out the answer to that directly is to basically go on the council's housing allocation policy. You just say Google it, housing allocation policy plus the council's name. And if we just kind of go down here, so what we can see, there's an introduction which is basically a lot of flim flam, really. But then we kind of get into where's it gone? Somewhere down here. So people who don't qualify, so your immigration status, so it kind of sets up, people who can't get onto the housing register because of where they're from or where they're coming from. Habitual residents, which could also apply to UK citizens who come back from other areas. High risk offenders, again, yeah, have a look for it yourself. Deliberately worsening your own circumstances. This is a little bit like intentional homelessness, but not quite. It's like the Part 6 version of it. Providing false information, homeowner and failed the financial test. So there's kind of various kind of hard criteria. But then if we actually get to kind of who can get on the housing register, then what we see here is that this is where it gets important. So the question comes from someone who I think is in private rented accommodation. And I guess the default is that private rented accommodation will be seen as being suitable. So to be considered to have a housing need, so you need to have a housing need to get on the register. If I read this properly, again, if you're out there, have a look through the policy yourself in detail because I've not had time to look at it in detail. But to be considered to have a housing need, you'll need to meet one or more of the following reasonable preference criteria. So overcrowding, affected by violence or threats of violence, need to move because of a medical condition, care leaver, homeless at risk of homelessness, which if you just, in a normal private rented accommodation, you're not homeless or threatened with homelessness, and kind of have some kind of welfare need. So my understanding is that unless you hit one of these criteria, you cannot get onto the housing registry in BCP. And then you've got these additional, even if you did meet these criteria here, you have these additional things. So things like local connection would come in at this point. If I'm reading this right, I feel like it is. Maybe not actually. Maybe I'm jumping ahead slightly. But yeah, basically have a look through this policy. This is where the answer will be. But ordinarily, someone who is in private rented accommodation in many council areas, not all council areas, but in many council areas, you'll be deemed to be suitably housed, and therefore you won't be able to get on the housing register. So that's kind of that's unfortunately the answer, which I don't think is very good news. But that's kind of my understanding of it. Thanks. Karis just sent me the link for that Tower Hamlets case. Let me just stick that into the live chat. Cool. For those who are interested, you can kind of find that there. So, and then the final question that's coming through the week. It's kind of interesting question. Probably we're not going to do this justice tonight. It's not like an individual question sort of thing. But this is on the back of the video I did last week about Imam v Croydon, as in this case which had huge implications where Croydon tried to say that they couldn't follow the law because they had no money, and the judge said, "Yeah, you do." And the judge basically said, you can borrow money if you need to, you can go and buy this family a house if you need to. A duty is one of those things you just can't get out of. And so the question is there a risk that eventually the legislation will be changed to water down the duties? And as I say, probably not enough time to do this justice here, but interesting nonetheless. I would say that personally, we in this country we've got kind of like an independent judiciary in theory, and it seems to me, having read a lot of cases, that judges do take this stuff very seriously. I mean, the Imam v Croydon case is a really good one to read. And just to see how the judge considered the council's pleas that they didn't have any money. The judge just basically was being very polite, but just was having none of it. And I think that judges are incredibly almost proud of the way that this law has been constructed. And I think it would, if a government tried to water legislation down significantly, I think they'd come across a lot of resistance, particularly around these low thresholds to get, to kind of get assistance in the first place. Now, I was chatting to Will and Karis about this before the live stream tonight. I would say that the HRA weirdly was actually watering down the duties, because although the HRA is much more onerous on councils in terms of the number of things they have to do, the actual offer of accommodation you get now is not as, well, it cannot be as good as it was before. So in one sense, that it made it easier for councils to discharge their duties into not so nice shorter term accommodation. But personally, I think it seems to me that it would take quite a lot for a government to really undo this good work. Now, I don't want to get too political here, but the only political party I would say that probably wouldn't take this stuff seriously would be Reform. And I might be unfair there. I'm basing it on people like Lee Anderson, who don't seem to have any time at all for social welfare law. But I don't think any of the other big parties would ever kind of look to kind of water this stuff down. I just don't think they'd get anywhere with it. But that's my answer. Will and Karis, I don't know if you've got anything you want to say at this point. It might be one of those questions we come back to in a different situation where we could talk about it more. But it's a good question. I like it.
Yeah. I'll avoid the temptation to sort of go on and on and on. But if you think I have failed to do that, stop me. But I think that these statutory duties are like sort of things that you see on the beach, that the salt water sort of works away on them and they get eroded, and eventually the water works its way around them and they collapse, unless something happens. So if you get something, for years, the test of priority need or vulnerability has seemed quite straightforward, but there's forever ways of whittling away at it. So, I mean, I think that they will water down the duties. Councils will water down the duties even if the legislation doesn't change, by sort of twisting and stretching the meaning of words. So, for instance, before the case, it wasn't, yeah, before Hotak, there was a case involving Sully Hull. If either of you can remember the whole name, but there they said that the test was that you've got to be more vulnerable than an ordinary person to be. You've got to be vulnerable, so you've got to suffer more harm than an ordinary person would suffer, or an able-bodied person, if they became homeless. But they managed to twist that so it became more vulnerable than an ordinary homeless person. And then they could say, oh, well, all homeless people are vulnerable. And so you're no more vulnerable than an ordinary homeless person. And then they'd have all these statistics about the number of homeless people that had depression and stuff. And eventually in Hotak, the court said, look, this is getting silly. Let's redefine the definition. And you'll see that happening in other areas too. We had that on affordability, just went on and on and on. People saying, in my day, people could afford this. And it just got ridiculous. You could you could live on a bowl of rice a week and then pay the rest of the shortcomings of the rent out of your benefits. So they'll keep trying that. And to conclude, the reason that is because there's a certain unreality about homelessness law, which is that you've got a rights-based system, and this is what the problem with Imam is for everybody concerned, is that the law says you must have this, but it doesn't say how you're going to get it, in the sense that the council will ultimately, in Imam, they're sort of putting their hands up and saying, well, sorry, we just haven't got it. And the law says, sorry, that's not good enough. And it's quite rare that you get such an open engagement on the actual issue, because normally there's some sort of mealy-mouthed way of saying we're not going to give it because we just haven't got the resources. But they'll try and say the meaning of the word in this case has to be interpreted in this ridiculous way in order to stop us having to do things which we can't do. Sorry, I hope that wasn't too
Yeah,
long.
no, that's cool. That's all good. Yeah. I mean, I think, I guess it's also important, well, it just kind of underlines why it's so important to push back on councils doing it. Because in one sense, councils get away with that stuff because no one challenges it. Charities don't challenge it. They don't challenge it
Yeah.
effectively. And so yeah, charities basically watch that definition of vulnerability get more and more ridiculous until, as Will said, HOTAC came in and it kind of reset it. So I guess, if you're working in a charity, this is another reason why it's so important to challenge councils when they're making perverse decisions, because not only does it leave that person in front of you homeless, it also just chips away at the kind of the application of the law. So yeah, I've just removed a couple of comments from the live chat because they're not anonymized. So you're very welcome to ask questions, but please just ask them as what if questions, not about your own situation. Hey, you're Anton. Hope you're well, mate. Yeah, Cheeseface just saying about how Hamlet's could have gotten her killed in terms of going back to the perpetrator. Absolutely right. As I say, the law on domestic abuse is really clear. And generally pretty good. Obviously, it's a very complicated issue, which is difficult to get it right 100% of the time. But the law does a good, makes a good effort at it, really. So I think the next question we got from the live chat is this one here. Check I'm sharing the right screen. It gets a bit confusing. Number 6, an individual is in interim accommodation and has been sent a personalised housing plan suggesting to them that they contact letting agents and also look for affordable private rented properties for themselves using the internet. Hold on, there's more to it. Is there more to it? No, that's it. Is that it? Okay. It feels like there's more coming, because that,
It's a quite well,
well, I mean, we can answer that if it was a
mistake.
question. I don't know. Is the next bit going to say that they don't have internet? I'm not sure. If that is a question, then I guess the council could advise someone to make use of the local library and use the internet there, that sort of thing. But obviously, it's a PHP can't tell you to do something that's not actually possible to do. But it can also, in the case where internet access is a problem, is the council can work kind of constructively with you to give you access to the internet in order to look for private rented accommodation. Now, when housing officers write that stuff into a PHP, everyone knows that is very, very difficult to do, but they're just doing it because 1 in 100 will find private rented accommodation, so they won't come back. But I think a good housing officer will acknowledge the fact that though it is a very difficult market, yes, you need to make reasonable effort without kind of making people kind of like just heaping sort of stress on them by saying that they have to go and do it. So yeah, that's yeah, we might get a bit more to the that. Oh, sorry. Here we go. So yeah, so let's just get this all up. There's some natty new badges in the live chat. I don't know if that's something I've done, because I was looking at I need to get your opinion sometime, guys, but not right now. Because I can kind of do this thing where kind of people pay for perks, like a few quid a month, you get like access to different videos and stuff. But I'm going to worry about that later. I don't know if because I've gone into that, people have got these different badges anyway. So yeah, so where do we go up to? The individual has been produced by the housing officer is not something that was previously agreed on with the individual. Does the individual client have to sign an agreement of the PHP, and what are the implications, next steps if the individual does not sign and doesn't agree to the PHP? Okay, so good question. Not quite what we thought it was. So right, this is like where the HRA just gets ridiculous. But let me just share the Homelessness Code of Guidance, which isn't even open yet. Let me just open it up. Because you basically got, within the PHP, there are mandatory steps and there are voluntary steps, whatever the word is. So hold on a sec, what's going on here? Don't want that. Sorry guys, I'm just going to have to. It's been very awkward. Right, let's try that again. Share, no. Yeah, cool. So here it is. So I'm trying to even think which chapter this will be in, because there's several chapters which talk about PHPs. But basically, yeah. So there are mandatory steps which it just gets really weird. See if it's in chapter 11. Because in some situations you can't. So I'm trying. It's either you can't challenge the reasonable steps that the council tell you must take, or the council will take, or you can't challenge the reasonable steps that you're supposed to take. So let's have a look here. So let's just read through a few paragraphs here to give you an idea of what the law says about this. So housing authorities should work alongside applicants to identify practical and reasonable steps for the housing authority and the applicant to take to help the person retain or secure accommodation. These steps should be tailored to the household and followed from the findings of the assessment and must be provided to the applicant in writing as their personalised housing plan. Yeah, so basically this is probably less useful. So personalized housing plans should be realistic, taking into account local housing markets. So this is what I'm saying about expecting people to go and find private rented accommodation if they don't have lots and lots of money, and the availability of relevant support services, as well as the applicant's needs and wishes. For example, a plan which is limited to the search for accommodation to a small geographic area where the applicant would like to live would be unlikely to be reasonable if there was little prospect of finding housing that they could afford. The plan might instead enable the applicant to review accommodation prices in their preferred areas, as well as extending their home search to more affordable areas and property types. I mean, even then, these days, this is probably not going to be very relevant a lot of the times. In their interactions with applicants, housing authorities are encouraged to provide sufficient information and advice to encourage informed and realistic choices to be identified and agreed for inclusion in the plan. Let's see. It would not be reasonable to agree steps for an applicant that were reliant on them engaging with a service provision that was not currently available. That makes sense. I'm sure there's more about this down. That's kind of examples. Okay, so it's not. Man, the answer is, guys, the answer's in this chapter somewhere, I think. So housing authorities should make every effort to secure the agreement of applicants to their personalised housing plans. Identifying and attempting to address personal wishes and preferences will help achieve that agreement. If the housing authority, so this is kind of getting to the part of the question here, if the housing authority is unable to reach an agreement with the applicant about the reasonable steps to be included in their personalised housing plan, they must record why they could not agree and provide the written plan to the applicant indicating what steps they consider it reasonable for the applicant to and the housing authority to take. So I'm not going to read through this whole chapter, but if you Google Homelessness Code of Guidance and you go to this section, so chapter 11, and you kind of go down from these paragraphs, recommended steps, that's the not voluntary steps, sorry, recommended steps. The answer's here somewhere. In fact, I'm going to read one more paragraph because I think it's in this paragraph. The personalised housing plan may include steps that the housing authority considers advisable for the applicant to take, recommended steps, but which the applicant is not required to take if they choose not to do so, as well as steps which they are required to take, mandatory steps. The relevant duty, prevention or relief cannot be ended for failure to cooperate with the recommended steps. The use of recommended steps might enable the authority to provide blah, 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 blah. Mandatory steps should be limited to those which the housing authority considers are required in order to prevent or relieve homelessness. The plan must set out clearly which steps are mandatory and which are recommended. So yeah, there's more to it than that, but that's the bit you need to check out. There is more to it, and there is, in terms of not, if you're deemed to have not cooperated with the personalised housing plan, the technical terms is like unreasonably and deliberately refused to cooperate or something like that, then the council then need to write to you to warn you of the consequences. And if you continue to not cooperate, they can end the relief duty. But that doesn't mean to say that they won't have a duty to house you, because if you're owed the main housing duty and you don't cooperate with the PHP, then you'll still get a final accommodation offer or a final Part 6 offer if you were going to be owed the normal main housing duty. So again, there's loads. I mean, it's so convoluted. If you go on the YouTube channel and you put the word refuse into the channel, they'll basically there's a video which is like, can I refuse the council's offer or something like that, and I talk about this in much more detail there. Plus you can read this chapter because, as I say, it's in here somewhere. The answers to those questions are here. So yeah, sorry that I don't know. Yeah, I don't read that chapter much because a lot of the time it's just doesn't really kick in my experience. The kind of the really useful bit about homelessness applications is actually making sure the application's made properly and showing that someone's in priority needs. What's written in the PHP is often not really something which is that important, although there are cases where it is. I know Will was talking about last week where someone was deemed to have not cooperated with the PHP because they hadn't supplied documents, which is probably ridiculous. But yeah. Will and Karis, you got anything to add to that one at all, or kind of yeah, sort of refine with what I've said there?
I was going to, I'm still planning to just come back to the bit about if if the personal housing plan says they should contact private landlords, yeah, that in itself isn't too bad because if it's the relief duty, then the duty is arguably to assist the person in finding accommodation. So they should be trying to find accommodation. So it wouldn't be an appropriate response to say, I dispute that I'm responsible for looking for anywhere. But there is a sort of elephant in the living room with this because most people know that there's no realistic prospect of success of finding private accommodation. Say in London, if you go looking for private landlords when you're homeless, you'll find that they're either unaffordable or there's people jumping the queue ahead of you that seem like more desirable tenants because they're more wealthy. So then you get this sort of unreality that the housing officer is saying, well, you've got to look, it's your responsibility, which is a bit like saying you've got to sort of swim the channel. I mean, it's something you could in theory do, but you're not likely to do it. So either you wait to the end of the relief duty and see if you can they'll accept a full duty, in which case that stops. Although they might still expect you to look for them. But if you're stuck and they're saying, well, you haven't looked hard enough, you could say, well, here's some evidence that I've looked. And if you think it's easy, if you think I'm doing something wrong, you show me where all these private landlords are, because in theory, if they're there, it's just me being lazy that's stopping me finding them. You can point me in the right direction. And the housing staff usually won't be able to do that because they know as well. It's just they're hoping if they keep saying it enough times, people just believe that it's the applicant who's at fault for not looking or not looking hard enough. Is that
Yeah,
helpful?
yeah, that's helpful. Yeah, I mean, I think
Yeah.
yeah, I suspect that the housing officers don't really put, yeah, they try this sort of thing, but if you really push back on them and said, yeah, as you say, we'll say, yeah, show me these properties I've been too lazy to find or whatever, then I don't think they'd really kind of put up much of a fight. I think they just, they just kind of say it because they hope that a certain number of people will go away and not come back.
And just the last point on that, I would encourage anybody who gets the personal housing plan that is limited to that, in terms of it doesn't say what the council are going to do, to request a review because I just checked a personal housing plan itself isn't open to review under section 202, but the steps section 202(1)(b)(1) says that you can review the steps which the local authority to take under section subsection hang on, I've lost it, but yeah, sorry, it's subsection 202 subsection 1 BA. It says you can challenge the steps that the local authority are to take under subsection 2 of section 189B, and I think that is the relief the steps under the relief duty.
Yeah,
So I think you could ask for a review and say, I think the local authority should be doing more, and recognizing the fact that just pointing me in the direction of private landlords isn't enough. I have no realistic, I don't think, based on my knowledge, I've got any realistic prospect of success in finding any. And if you dispute this, please show me some evidence of available private sector landlords who I'm failing to attack. Basically the same argument.
yeah.
But then
So
again, it's probably going to be academic after 8 weeks because then
yeah,
it ends.
I mean, the bit you just read out there would suggest that. So yeah, so as I say, it seems like it's that way around. So you can challenge the reasonable steps that a council is agreed it will take, but you can't challenge the reasonable steps that you're supposed to have taken, the mandatory ones, that
Yeah,
is. which is
Yes.
again, it's I remember reading it in Jan Luber's textbook. He kind of said this is like this is a little bit a little bit weird. He was kind of more polite about it than that, but he just kind of that's a little bit of a weird sort of imbalance there. Karis, do you have anything to add to this one?
All right, and there is an ongoing debate about private renting taking people on benefits, and when they refuse, if it amounts to discrimination. So even though people are told to find private rented accommodation, if they're on benefits, they're often refused. So that's not taken into account.
Yeah.
Yeah. There's a bit. I've just noticed a bit more to it in the live chat on this one. Since the PHP is that you are advised to do this and that. So does this mean it's not mandatory? I mean, I would say that I would say you're fair to read it. I don't think it's ever going to come down to a particularly detailed argument with someone about it. I guess maybe the textbook answer there is to kind of go back to them and check, saying, look, is this a mandatory step or is it a recommended step? But yeah, if I was advised to go and do this, I would say that sounds more like a recommended step than a mandatory step. I'm sure the council might still try and argue that, but yeah, I don't think it's ever going to come down to it really. Again, just to kind of give a big picture kind of overview of the stuff. This is why priority need matters so much, because if you're not in priority needs, then there is no teeth to these. Often there's no teeth to these PHPs. Because the council can just let it all run off for 8 weeks and then just shut down the relief duty altogether. Whereas if you're in priority needs and you're eligible and you've got this far, then there will be some kind of housing duty for you, even if you're intentionally homeless. So yeah, but yeah, really, yeah, good question. If I just go, I just want to make sure I've not missed any here. So where has it got? So yeah, just right. It's a multi-part. So just give me a second to load it up. Cool. I think that's all of it. So, vulnerable tenant hasn't heard anything back from the letter put through letterbox last week. So I don't know which letterbox this is. It's either going to be the courts or the councils, is my guess, or the landlords maybe. They now owe over £1,000 rent arrears due to no income, no universal credit. Why do they only open post certain couple of days a week? Knowing vulnerable people post is urgent. I guess, I mean, in one sense, obviously we don't know the answer to this, but this particular, whichever organisation this is, but as a general rule, the way that many organisations, courts, councils, landlords, whoever, the reason they don't do this efficiently is because it's not in their interest to do it efficiently. There's this concept of weaponized incompetence. But Professor Luke Clements talks a lot about it in the book Clustered Injustice, because in one sense, what he's saying is that councils deliberately don't put enough resources into staff in these kinds of roles to actually answer posts quickly or whatever, because by not answering it quickly, they can save themselves a lot of work down the line. So if you don't have enough housing officers taking homeless applications, then you're going to be bouncing a lot of homeless applications away, and that saves the council hundreds of thousands of pounds every year. So in one sense, organisations don't do a good job with this stuff because they don't care, and in one sense, it is in some cases deliberate. They are basically making it more difficult to kind of contact them. This is why it's very difficult. You try and ring someone up, you've got to wait like an hour and a half to get through to them. That's a political choice by the council to not have enough people staffing the phone or opening their letters or whatever. So it's not a happy answer to the person asking the question, but it's not. Yeah, it's deliberate. It's something which but I guess it's just important to understand when you deal with these organisations and deal with housing officers or whoever, they don't care that much a lot of the time. Sometimes they do, but most of the time, I think the housing officers put into these positions where they're not properly resourced. They either leave the job or they just they come to terms with the fact that they're not going to pick up on important situations and they're going to miss opportunities, and they're kind of okay with that in some way. So yeah, I'm not quite sure what else to say about that question. But it's not unique, but it's just to understand that a lot of organisations don't care. That's the answer. They don't get paid to care, unfortunately. So next question, unless I've missed one, I think I've got all these so far. So Oh, why is it not doing? Give me a number. Oh, hold on a minute. Let's try that again. There we go. So this is just another multi-part. Just as I always say, guys, if you want to not have a character limit and get your question answered at the beginning of the live stream, then just ask the question in any video on the channel. Just anonymize it still, but I get a notification. I'll basically bring it to the beginning of each live stream. I do have a question to ask, if okay. Yes, it's okay. At my place of work, a homeless drop-in centre, we are having a number of people presenting on expired work visas, no right to remain, and it's quite a grey area as they're unable to access housing benefit, DWP benefits, so etc. So a lot of places seem to have a blanket "we cannot help or accommodate" approach. Any suggestions, please? So, yeah, I mean, people who are not eligible for housing assistance or eligible for housing benefit or whatever, there are going to be very few housing options for them. There are one or two charities in the country which will give a limited number of kind of bed spaces to people without recourse. So Emmaus do a few. I don't know if every Emmaus does it, but certainly some Emmauses do it. Personally, my experience of working in this kind of situations is you need to have very honest conversations with people and say, what are your long-term prospects here of staying here? If there is a prospect to you staying here, if there is a prospect to you finding work or whatever, okay. I've certainly worked with people who basically chose to return to their home country because there was no prospect of staying here, and basically staying here, they were just kind of deteriorating more and more. I don't know what the UKBA, if I don't even know if the border agency is still called that these days, in terms of kind of people in the situation. But so I don't think there's really much chance of it kind of being enforced. But yeah, I think it's just that kind of having those honest conversation with people and saying, what there is very little assistance for people here without recourse to public funds from in terms of housing. Yeah, what are you going to do about that? So I think, yeah, it's a difficult job, but I think realistically, I think there's a danger that you end up helping people stay in the country, only to end up kind of getting worse and kind of getting stuck here and not actually getting any better. Certainly when I worked kind of front yeah, kind of rough sleeper outreach services and stuff, the group of people who are at risk of highest risk of death were people without recourse to public funds because because of the situation they're in. And a lot of people who ended up dying had basically stayed in the country long after they weren't able to get help, and they just basically seemed to kind of rot away in front of our eyes, really. So I think it's a very difficult job for charities to kind of work out what to do. But personally, my belief is leaving people in that limbo is not good for them. That it's better to find another option. So yeah, appreciate that's quite a contentious issue. But yeah, I think that the answer is there's not a lot of help, unfortunately. So yeah, Willa Karras, I don't know if you've got a different perspective on that or something to add to that.
Just quickly, because this is a very big subject, really. The You're right. It is difficult. If somebody is from abroad and they don't have a right and they're not entitled to be here, or they're not eligible, but according to the definition, then they're not going to be able to apply as homeless in the normal way. The question, so let's see if the person had they were on an expired work visa and no right to remain, that would mean that in theory, well, it means they're not eligible and they could presumably be deported if they were to present themselves to the Home Office or so the question is if somebody's got children, then they may be entitled to accommodation under Section 17 of the Children Act. And if somebody's got needs that mean that they're eligible for support from social services, adult social services, which they would need even if they weren't homeless. So you'd have to sort of be eligible to have somebody come and help you get dressed or help you with forms or something. You could be housed through either of those routes, but you'd only be entitled to pursue that if you had some legitimate reason to be here. And so for instance, you had an outstanding application for leave to remain. And then it starts becoming an issue of human rights because you can't be, if you've got a human right to have your immigration case processed, it undermines that if they deport you while it's going on. So it's quite complicated, but basically, unless they've got somebody on an expired work visa who hasn't got an application that would legitimize their immigration status is in trouble. So they'd have to make an application or demonstrate to Children's Services or Adult Social Services that they were going to do so. I hope that helps.
Yeah, yeah. I think contrary to kind of public perception, for people who don't have recourse, there isn't a lot. There really isn't much positive support out there. And as I say, I think there's a risk that people kind of get trapped in these kind of situations where they're street homeless or kind of in just very precarious situations, and the long-term prospects are pretty poor, really. And as I say, kind of it's kind of important to have sort of adult conversations with people in that situation to work out what the realistic ways are forward.
I would also add, so no recourse to public funds apart from the Care Act and the Children's Act. There's also trafficking and victims of violence. So especially when it's a work visa, in terms of certain types of sectors of work, there's a lot of trafficking. So that can also be a possibility. And if they're doing a blanket approach of just everybody, that's what you're getting if you're working at this charity. And you're applying to the same council, and that's the approach you're getting time and time again. This should be recorded, and you could start gathering evidence for that possible judicial review for that blanket approach, because it would be discriminatory. Because if that's their policy, that's their blanket approach, that's discrimination because it can't apply to everyone. And that's where you go to the a charity that or a law centre that can challenge that blanket policy.
And building on that, if you've got concerns that someone is kind of experiencing trafficking or some sort of exploitation, then I'm pretty sure still that the first point of call is the National Referral Mechanism, the NRM. But I mean, there are other charities that do it specifically, but I think if you go to the NRM first, if you just Google it, then you can potentially get into that system, which provides some support for people who have been trafficked. Cool. Question 9. And so I've just put a message in the chat as well. So we're going to kind of close questions down. So any questions after that message I put in there, you'll have to roll on till next week, unfortunately. So as I say, if you put the question onto any video on the channel, you'll guarantee getting it answered next week. If you wait to the live stream to put it on, you don't basically. Well, there's no guarantee. So number 9, a friend made homeless application 3 weeks before being homeless, but her council have denied this. Now she has gone to the LGSO. What can she do? She's worried the council wiped this form from files. So councils do falsify evidence. They do delete things. And unfortunately, my initial answer is not going to be terribly helpful for this person, but just to say, if you had a time machine to go back, this is why it's so important to email homeless applications from the start. And this is why I hate online portals and so on, because you just don't have that proof. So this person's done absolutely nothing wrong. This person's basically in good faith tried to do the right thing and kind of used the council's form, whatever. Yeah, I guess it's going to depend slightly on kind of what kind of what form or kind of what process was used to trigger the application. Was it, did this person just kind of go into the council and speak to a housing officer? That's very easy for a council to deny happen. Same with the phone call, although I guess with the phone call you can at least prove you made the phone call, even if you can't prove what was said. But this stuff happens alarmingly often. If I was homeless myself, I'm not advising people to do this, it's up to you. But if I was homeless myself, if I ever had a phone call with a housing officer, for example, I'd record it covertly, which is legal to do because I then have this kind of record. Now, with the LGSO, if you provide a coherent, kind of credible account of what you did when, and if you have got any proof, then great, then certainly the LGSO are not bound by what the council say happened. If you've got credible evidence to say you made an application 3 weeks before you came homeless, then the LGSO are, they may well actually side with you, because they're putting these decisions out. The one I did a video about a few weeks ago was Houghton Council, where they basically lied about what they'd done, as in the officer had lied about what they did. But yeah, unfortunately, this is huge power imbalance between homeless people and councils. One of the ways that power imbalance is abused is by housing officers just deleting stuff, basically. I saw it firsthand when I worked at Bedford Borough Council, but it obviously happens in other councils as well. So I think the best you can do is kind of give a credible account of what happened when, and kind of hope that the LGSO are going to kind of believe you basically. I don't know if you guys have got a better answer than that, Will or Karis.
No.
Um,
No.
yeah. So yeah, it's just as I say, for those. I mean, again, this is no use for the person asking the question. But for those who are looking to approach a council, there's a video on the channel called "The Best Way to Make a Homeless Application." Again, that's what I would do if I was homeless. Those are the steps I would take. And yes, it seems overboard, but this kind of situation is not unusual where you approach a council and they deny that ever happened. So yeah, good luck, and I hope the situation's sorted out kind of yeah, somehow. Right. So I've done that one. Not sure if there's a question in that. Okay, so here's a question. By the way, guys, if you find this stuff useful, as always, just kind of give it a like and give it a share or whatever. So yeah, it does make a difference in terms of how many people see this stuff. And my view is that more people challenge councils, the better it's going to get for everyone. Number 10, does the waiting time for housing start from priority date or date moved into temporary accommodation? Thanks. So, okay, so we just need to be very pedantic because the law's pedantic here. Priority date is not a legal term. So the in terms of the waiting time, I mean, it depends how you kind of, I guess, yeah, I'm sorry to be kind of get all semantic about this. It depends what you mean by this. In one sense, the date that matters is the day the council accept that they owe you the main housing duty, or the date they accept the final accommodation duty or final Part 6 duty. That's the date which matters. Everything that happens up to that is kind of you're in kind of limbo. So and if you're owed the main housing duty, the law says that it should really be, the decision should be made on day 57 from the relief duty being accepted. Now, even with that, there's a bit of jargon there because the relief duty doesn't start the day you make the application necessarily, although it can do. It starts the date the council's satisfied you are homeless and you are eligible. So this is another example of where the HRA watered down the pre-existing law, because before that they had to make a decision within 33 days. But now it's like more than 56 days. So, but the date, that's the date that matters. Now, in terms of priority date, I don't know here if you're actually talking maybe about the housing register, like the banding date potentially. In one sense, if you're talking about someone who's already on the housing register and they've just been given band B, then the date they get given band B is the date that matters. The date they move into temporary accommodation is not directly linked to the waiting times, because will have people who make an application that don't move into interim accommodation at all, and the application's still running. So that's the kind of distraction. The important kind of landmarks in the homeless application process are the day you actually start the process from scratch, the date that the relief duty starts, the date the relief duty ends, and that should be the day before the main duty is accepted or not. And then the date you actually get onto the housing register, potentially if you're talking about social housing. So sorry to kind of like complicate the question there, but I think that's my answer to it. Again, Will or Karis, I don't know if you've got a better interpretation of the question or kind of a better answer than that.
I don't think I can add to that.
Yeah, okay. So is this a related question? So question 11. An individual is in interim accommodation. Can the council come up with a decision of priority need at any point during the 8 weeks review, or do they always come with a priority? I don't quite understand that question. So, okay, the 8 weeks is like there's a number of points in which process that we talk about 8 weeks or 56 days. So the relief duty is 56 days, but the review process should be 56 days. And there's no reason why the council don't have to wait until the end of that 8 week period to make a decision on the review. They can do it any time. They can do it the day after you make the review because they realise you're actually in priority needs. But a lot of councils will just delay it again. They'll actually go far. They'll go far way past the 8 week limit in a lot of cases. So I don't know. Again, I'm maybe just not understanding that question very well, but that's my answer.
I have a shot at it. I don't want to
Yeah.
drag things out because I'm assuming that 8-week review should say 8-week relief duty. And so the individuals in interim accommodation.
They might, I don't know if they mean temporary accommodation, maybe, because again, it's jargon that a lot of people
Because
won't know the difference.
so normally the issue of priority need is relevant to whether they give you temporary accommodation during the relief duty, because they could just say we accept a relief duty and here's, the usual advice applied to local landlords, etc. But then you say, well, hang on, what about temporary? And they say, oh no, we haven't got reason to believe that you're in priority need. And
I
that is
think there was an add-on, sorry.
Oh, is there more?
Sorry.
Hold on a sec. Let me just dig it out.
At the last, decision at the end of the 8-week is what's missing from the question.
Where's the add-on? So
Hold on a sec. Let's just.
further down. Oh yes.
Yeah.
Is that a bit right? Karis, have I just done that? Is that the bit you're seeing? So yeah, again, I can see more from this person, but I'm not quite sure if I've missed a bit.
Oh well.
Yeah.
Does it change what I was?
I'm not sure yet.
And
So
there's
just to
more.
say, guys, I think a lot of you missed the time limit on not asking questions.
Yeah.
So for those questions which are kind of, I don't know how many questions we've got left to actually answer this. For those questions that didn't get answered tonight, just to reiterate, if you put questions on any video on the YouTube channel, this YouTube channel, you will guarantee getting them answered next week. If you wait to the live stream to ask them, then you will not guarantee getting an answer. So I think I've added the additional bits, but let me just read it again. So an individual is in interim accommodation. Can the council or local authority come up with a decision of priority need at any point during the 8 weeks review, or do they also have to come up with a priority? If an individual is given a priority decision and offered main duty after their PHP does the PHP cease if an individual is given priority decision? Okay, yeah. So right, okay. I think I'm following it. So the PHP becomes irrelevant once the council make the main housing duty decision. If they accept the main duty, the PHP is no longer relevant because the relief duty is now ended. And councils cannot make a positive main housing duty within the 8-week period. This is ridiculous, but this is the way the law works. So they might know from day one that you're going to be owed the main housing duty. They are not allowed, or they're advised against, according to the guidance, making a decision within that 8-week period. So yeah, as I say, but then and is no longer. And can the council place an individual in the private rented sector after offering the main duty? Yes, they can. So there's a video on the channel called "Will the council give me? Will I get private rented or council housing or something like that?" So again, there's no guarantee of getting social housing at any point, and you can't make the council give you social housing. They might owe you the main duty. They can discharge that into the private rented sector if it's a 12-month assured short hold tenancy. And I don't know what that's going to look like once the Renters' Rights Act come in later this year, because I assume there's no such thing as an assured short hold tenancy at the end of this year. So we don't know quite yet what that's going to mean yet. But I don't know. I'm hoping I've answered the question there. So okay, let's go and see. So I think we've actually only got one more question. Yeah, one more question before the time limit tonight, guys. We've already gone over the time. So thanks, Will and Karis, for hanging around. So this is the last question for this week. For those who didn't get a question answered, stick your question in the comment section of a YouTube, this channel. Basically, you'll get the answer next week. Number 12, what should an email consist of when the average wait has come and gone when trying to inquire how long it would take to be permanently housed? So once the council's owed you or accepted it owes you the main duty, average waits are just averages. So if one person waits 1 year and one person waits 22 years or whatever, then the average wait is 10.5 years or whatever the maths works out as. Just because you're now in temporary accommodation for 11 years, there is no, the council still won't necessarily know on an individual basis how much longer you need to wait. There's a lot of different factors which will have a bearing on it, things like disabilities, household makeup, that sort of thing. So you can always ask a council how much longer do you think it will be, but 99% of the time the council will come back and say we don't know, and they won't be able to be they won't know any better than that, really. So all you can assume is that if you're bidding, if you're in the housing registry, if you're bidding consistently and sensibly, then that is the only thing you can do to speed up your kind of final housing. And obviously, if they're going to make a private rented offer, then that's kind of that's up to the gods, so to speak. There's nothing you can do about that really. So yeah, so you can always chase and always ask the council for kind of an update, but they don't have to tell you, and they can't really, they can't tell you, well, it's going to be another 5 years, because it's all averages. You can never pin it down. The bit of work I did around showing average waiting times, they're just averages, so it shows that it's on average better to approach one council than another, because the waiting times on average are less. But that doesn't exclude the possibility that someone would get housed very quickly in a place like Croydon, which ordinarily would take ages, and someone goes to Bassetlaw, which are ordinarily very short, and get housed in 20 years time. There's nothing stopping that happening. So unfortunately, I can't be any more precise about that really. So yeah, I think that's it, guys. As I say, for those who put questions in and missed the boat, sorry. But yeah, just kind of, just put the questions into the channel in the week, and I'll therefore guarantee getting them answered next time. Can you keep the questions short? There was one question I didn't answer this week because it was like 2 pages long. You need to basically make it easy for us to be able to understand what the question actually is. Otherwise, it just gets very murky. So I know one person kind of separated their different questions into different points. That was a really good way to do it, because they had multiple questions. You can ask multiple questions, that's fine. But it just needs to make kind of sense for us. So yeah, Will, are you planning to be on your channel this Monday?
Well, yeah, I mean, I feel sort of insincere if I say yes, but I'm planning to be. It's just last week it was so hot that I had to sort of take all my system apart and go downstairs, and I couldn't do the live stream from there. But if the weather permitting, yes,
Yep.
I will aim to do that.
Yeah, cool. Okay. So yeah, that's it for this week, guys. For those professionals out there who are watching, there are spaces now available on the September and October training dates, day-long online courses. So have a look on the Eventbrite link in the description to find out more about that. But yeah, other than that, guys, hopefully tonight's been helpful. Sorry that we can't answer all the questions. It's just the nature of life, I guess. We'll try our best. And for those who didn't, as I say, didn't get on this week, just stick it into the channel in the week, and you'll guarantee getting an answer next week. And if we get if I get 50 questions on the channel in the week, I will do a special live stream or something just to make sure we get through them. So I will guarantee it. If I see them and they're kind of sensible questions, I can understand what they're talking about, then I'll answer them next time. So yeah, take it easy, have a good week. And hopefully see you on Will's channel on Monday.